Hello, I'm back. Oh boy. Oh boy, oh boy. It's been some time. Hello, everyone. How is it going? Give me the tea. What is up? I have tea for you guys, but this is about Bryan Kohberger tonight. So, hello, welcome. Let me say hi to everyone. Can you guys hear me okay? We're all good in the hood? Hello. Hi. Let me say hi to everyone. Hello, thank you for being here. I saw 𝗏𝗏, I saw Debbie, 𝗵�cy. Shout out all the mods, 𝗏𝗏𝗃𝗲, Amanda, Patty, number 7. Razón, Irony, hello. Pantera, hello. Thanks for being here, guys. We're going to be covering Idaho 4 tonight, the documents. I'm a little behind. Your girl has been busy, but thank you for being here. So I'm excited to talk about these documents. I have not read them. There is a lot. Oh boy, there's too much. We're going to try to get through 3 of them tonight. The ones I want to hear about, we're going to play a few clips. We're going to go over the Bushy eyebrows document. We're going to go over the text messages and the 911 call documents. And then we'll see where we go from there. But thank you for being here. All new viewers, hello. Welcome. My name is Melly. We cover true crime here. I do plan on doing Melly After Dark too, so we'll see what the vibes are. But thank you for being here. Make sure you hit the like button. Hello, 𝗶𝗶𝗃𝗲. Hello, number 7. Let's get started. Okay. First document. Hello, Kay. Poor Kohberger for 45,000 tips. And the prosecution is only looking at him. Yes, let me know in the comments what you guys think. I know this is a wild case. I have been following it, just not so much on my channel, but we're going to today because you guys know I like to read documents. I love to read documents. So let's get started. Hello. Good to see y'all. It's been a while. I know I haven't been live. Don't get discouraged. Don't be sad and don't be happy. I'm back for the rest of the week. So let's get started. First document, let me make sure I have the right one pulled up. Yeah, I do. So the first document was filed February 24th. And this is the motions in limine for the text messages and testimony. We're going to get through the boring parts, but we'll get through all the good parts too. Hello, Patty. Hello. Good to see you. Okay, let's get started. I know there's a lot to catch up on, but for now, let's catch up on Bryan Kohberger. So this is the text messages and it's wild. The pictures. Oh, I did want to pull up his picture because I know a ton of you want to see that creepy picture. I can't get over it. I can't stop looking at it. Not because he's a creep. Do you think Bryan Kohberger is innocent or do you think he is guilty? I'm curious. Okay, let's pull up his picture real quick. I know. Thank you, Pantera. Thank you. Right off the bat. Thank you for gifting the memberships. And everyone who got a membership, please thank Pantera. That is so kind and so nice. Oh, there we go. Oh. Yay. 𝗏𝗏𝗃𝗲, good to see you. No, 𝗏𝗏𝗃𝗲, you're not late. You were early. I'm late. Your girl's been busy. Guilty, says 𝗏𝗏𝗃𝗲. Yeah, I know 𝗏𝗏𝗃𝗲s has been definitely keeping up with this. Again, thank you, Pantera, for gifting the memberships. Welcome all new members. Let's see who got them. Okay, cool. Welcome all new members. This is Bryan, guilty and creepy. Right. Yeah, he is. I'm shook. Amanda's like, no, please. Yes, please share, comment, and subscribe. Thank you, Pantera, for reminding everyone. Okay, let me pull up the document. I just wanted to share that picture because he's creepy. So creepy. Oh, my bad. Tipsy says, I'm leaning more towards guilty too, but I'm looking forward to hearing more details. Thank you, 𝗏𝗏. Thank you. Okay, let's get started. Can you guys see that? Okay, yeah, you can. State of Idaho against Bryan Kohberger. I've not read these, so bear with me. We're going to get through them tonight. Respectfully moves the court for an order in limine, allowing the state to admit text messages of DM. What is DM's name? I know BF is Bethany. It's redacted here, but we know. What is DM's first name? I can't remember. I know you guys know. I did this on my other live too. What's her name? Is it... Somebody please remind me. I feel bad. Is it Dylan? Okay, thank you. Why do I always want to say it's like... I can't remember what I said last time, but I got it wrong last time too. I'm sorry. I mean, no disrespect. So Dylan on November 13th, 2022, and testimony from Dylan and Bethany regarding the conversations with each other on November 13th. It is Bethany, yeah? The grand testimony of DM and BF was provided to the defense as part of the grand jury record. This just goes over why it should be included. I'm not going to read that part. Let me see. Yes. Oh, it's okay. I didn't even know it, so you're fine. Both exceptions were... Oh, let me read through these exceptions, I guess, since we're... In general, testimony that is hearsay is excluded at trial. However, there are exceptions to this rule. Two firmly rooted exceptions are the Idaho rule of evidence, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. A statement relating to a startling event or condition made while the declarant was under the stress of excitement that is caused. The requirements of the federal version of the present sense impression and exited utterance are best stated in U.S. versus Mitchell. There are three principal requirements which must be met before hearsay evidence may be admitted as a present sense impression. The declarant must have personally perceived the event described. The declaration must be an explanation or description of the event rather than a narration, and the declaration and the event described must be contemporaneous. The requirements for a hearsay statement to constitute an excited utterance are startling occasion, statement relating to the circumstances of the occasion, and a declarant who appears to have an opportunity to observe personally the events, and a statement made before there has been time to reflect and fabricate. Both exceptions require that the declarant personally perceives the event or condition about which the statement is made. In addition, both have temporal limitations with limit admissibility. Under the present sense impression exception, the declaration must be substantially contemporaneous with the event in question. The fundamental premise underlying the present sense impression exception is that substantial contemporaneity of the event and statement minimizes unreliability due to the defective recollection or conscious fabrication. Let me zoom in. There we go. Courts have given broader temporal limitations for excited utterances. Following Napier, some courts have admitted excited utterances made well after an event when the declarant was suddenly subjected to rekindled excitement, because events may so deeply traumatize a person that long after stress has subsided, a chance reminder may have enormous psychological impact, causing renewed stress and excitement and inducing utterances relating to the original trauma. There's no requirement within the language that the declarant be excited or emotionally affected by the event or the condition in order to fall within the present sense of exception. But if so, then the statement can overlap with excited utterance. Argument. Let me touch base with you guys. Hello, not my job. Hello. Good to see you. Good to see you. Hold on. I want to pull up. Yeah. Okay, cool. Argument. Dylan's phone records for November 13th, 2022 and Bethany testimony told her should be allowed. DM told her should be allowed at trial. In the case at bar starting on November 13th, 2020 at 10:29, DM sends a text message to EG, the Uber driver, to inquire if he is driving. The state submits this text message exchange is not hearsay because it will not be offered for the truth of matter asserted. Instead, it would be offered to show a timeline for the night. DM was awake and texting at 10:29. DM attempts to call BF. Xana, Kaylee, and Madison Mogen, all calls unanswered. The records of these calls are not hearsay as they each do not meet the definition of statement, oral assertion, written assertion, or nonverbal conduct intended as an assertion. From 4:22 to 4:24, DM and BF sent the following text messages. We're going to get started on the text messages now. Hello, Timo. Good to see you. DM to BF. No one is answering. DM to BF. I'm really confused right now. DM to Goncalves, Kaylee. And then DM says to Kaylee, what's going on? BF says to DM, yeah, dude, WTF. BF to DM says, Xana was wearing all black. DM to BF, I'm freaking out right now. And then DM says again, no, it's like a ski mask almost. BF says, STFU. BF says again, actually. DM says, like he had something over his head, over his forehead, and little in mouth. So there's like typos there. And then DM says to BF, I'm not kidding. I am so freaked out. BF says, so am I. DM says, my phone is going to die. FUCK. DF to DM says, come to my room. Run. Down here. All of the above declarations are present sense impressions and excited utterances. This is supported by DM's grand jury testimony where she indicates she just witnessed a startling event. She heard noises in residence and saw an unknown male in the residence. The declarations indicate both BF and DM are trying to make sense of the startling event. Contemporaneously or immediately following the startling event, i.e. no time for reflection or fabrication. See DM's grand jury testimony. At 4:24, DM calls Ethan Chapin. The call is unanswered. This phone record, like the other records of calls, is not a statement pursuant to IRE 801. DM and BF continue to text. At 4:24, DM texts BF, I'm screwed though. And BF responds at 4:25, yeah, I know, but it's better than being alone. Again, both statements are admissible as present sense impressions and excited utterances as they are describing an event or their state of mind or are spontaneous reactions to that event rather than the result of reflective thought. At 4:27, DM calls Goncalves, call unanswered. And at 4:28, DM calls Xana, call unanswered. These are not statements. At 4:32, DM sends a text message to Kaylee stating, please answer. The statement is a present sense impression. It shows DM's perception of events and an excited utterance, spontaneous reaction to that event rather than the result of reflective thought. This case is so wild. The next morning, DM sends the following text messages starting at 10:23. DM to Kaylee, please answer. DM to Mogen, are you up? DM to Kaylee, are you up? These text messages are not hearsay because they will not be introduced for the truth of the matter asserted. Even if deemed hearsay, they are allowable as present sense impressions as they reflect of consistency and continuation of DM's text messages from the night prior and reflect her then perception of what was then occurring, which is waking up and realizing that she had not heard from her roommates. So, and I'm not here to point fingers. All opinions are welcome here as long as you are respectful. We're all entitled to it. Opinions are not contagious. But she saw someone with a black mask, but why would she, I mean, not that she would assume her friends were dead, but I don't know. Something doesn't seem right here. I would be concerned a lot more earlier than 10 in the morning, right? Sounds toxic. Yeah. Hello, Sam. Good to see you. Hello, Against All Logic. Thank you for being here. What do you guys think? At 11:39, DM has a text exchange with her father, BM. These statements are not hearsay as they will not be introduced for the truth of the matter asserted, but instead show a timeline for the morning. At 11:50, DM receives a text message from J stating, bro. This text message will not be introduced for the truth of the matter asserted. At 11:50, DM calls EA. This phone record is not statement pursuant to IRE. DM receives a text message from J at 11:51 and a vandal alert at 1:04. These texts are not hearsay because they will not be introduced for the truth of matter asserted, but instead to show a timeline for the morning. Who's J? I'm sure many of you know the answer to that. So the next one, DM and BF testimony. The state anticipates that both DM and BF will testify at trial. The state intends to ask each witness about statements made to them on November 13th, 2022. This testimony should be substantially replicate the testimony they provided at the grand jury proceedings. The state submits the statements from both DM and BF to each other are allowable hearsay because they are present sense impressions and or excited utterances. Previous adjudication. Judge John Judge has previously ruled that the text messages and statements of DM to BF are present sense impressions and excited utterances, holding both the text messages and the testimony of BF as to what DM told her were admissible as exceptions to the hearsay rule. Sealed order denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Page 20, filed 12/15. DM's phone records for November 13th, 2022, and BF's testimony are allowable at trial under Crawford. Present sense impressions and excited utterances are admissible whether or not the declarant is available as a witness. That's wild. The state submits if any of the declarations made were deemed testimonial, both DM and BF will testify at trial anyway. Conclusion. Based on above cited authority, the state respectfully requests the court's approval in limine of the admission of the text messages of DM on November 13th, 2022, and the testimony from BF regarding what DM told her on November 13th, 2022. And that was signed on February 24th. Hello, 4Gene. Good to see you. We're going to move on to the next one. I want to read the document on the night. I might not be going, I'm trying to go in a specific order, but there's a lot of documents. So we're going to have to cover all of them, but clearly not tonight, all of them. There's a lot. The next one is the redacted state's motion for the 911 call. Thank you, Pantera. I appreciate you. Let me pull that up. Pantera says, let me buy Melly a drink. Shout out to everyone and the cool people and new people. Yes, I know. It's been a while. Thank you, Pantera. I appreciate you. Vandal is a mascot for Idaho, and it goes out as a phone alert to all students. Thank you, S-Dubs. I didn't know that. Thank you. That's very helpful information. And thank you, Pantera, for the super chat. So this one was filed on the same day. Yeah, 2/24, a little bit after the other document. Comes now the state of Idaho by and through Latah County and prosecuting attorney respectfully moves the court for an order in limine allowing the state to admit the recording and transcript of the 911 call to Whitcomb on November 13th, 2022. The 911 recording was discovered and the transcript was discovered as bait. I do want to play the 911 call. I feel like I haven't listened to it in a minute, so let's play it. I know it's so brutal, I know. But I haven't listened to it in like a week. So let's listen. I'm going to play the News Nation clip. Let me pull it up. I know you guys have probably already heard it, but let me rewind it. I'm sorry. I need to remember that. I can't believe how much new info is coming out. I know, right, Gypsy? I know. Let's see. News Nation has the call.
For yourself. Play it.
911 location of your emergency.
Hi, something is happening. Something happened in our house. We don't know what.
What is the address of the emergency?
1122.
What is the rest of the address?
Oh, Kings Road.
Okay. And is that a house or an apartment?
It's a house.
Can you repeat the address to make sure that I have it right?
I'll talk to you guys. We live at the White, so we're next to them.
I need someone to repeat the address for verification.
The address, 1122 King Road.
And what's the phone number that you're calling from?
What's your phone number?
And tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night, and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. Yeah. Hi,
and are you with the patient? Okay, I need someone to keep the phone, stop passing it around.
Can I just tell you what happened pretty much?
What is going on currently? Is someone passed out right now?
I don't really know, but pretty much at 4 a.m.
Okay, I need to know what's going on right now if someone is passed out. Can you find that out?
Yeah, I'll come. Come on, but we gotta go check. But we have to. Is it passed What's wrong? She's not waking up.
Okay, one moment. I'm getting help started that way.
Okay, thank you.
Sorry for the noise. He's like, let's get out, get out.
Okay, and how old is she?
She's 20.
20, you said?
Yes, 20. Here's one.
Okay.
Hello? Hello?
Okay, I need someone to stop passing the phone around because I've talked to 4 different people.
Okay, sorry, they just gave me the phone.
Is she breathing?
Hello?
Is she breathing?
No.
Okay.
You need to talk to them, okay? I can't talk to them. They need you to talk to them.
Hello.
Okay. I've already sent the ambulance and law enforcement. Stay on the line. If there is a defibrillator available, send someone to get it now and tell me when you have it.
Say that again? There's a police here right now.
Okay. If there's a defibrillator available, send someone to get it now and tell me when you have it.
We don't have one. I think yes. Do you have a defibrillator? Yes, you have one.
Are you talking to the officer?
Yes.
Okay, I'm going to let you go since he's there with you and can help you.
Okay.
Thanks for watching.
That call is brutal. And the heavy breathing, how creepy is that? 𝗃𝚉 said something earlier. I can't believe how much new info is coming out because of this different judge. And that's so true. I'm curious to know what she was going to say before she was cut off by the dispatcher. Yeah. This is wild. My heart goes out to the families. How hard must this be too, right? Having to like go through all of this, but I really can't wait to see the trial and people testifying. So the argument, this is the document on the 911 call. So, oh no, sorry, the facts. The facts pertinent to the issue raised by this motion can be found in the attached excerpts. The argument is the statement on the 911 call are hearsay, but fall within firmly rooted hearsay exception and should be allowed. In general, testimony that is hearsay is excluded at trial. However, there are many exceptions to this rule. Two rooted exceptions are present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. Excited utterance, a statement relating to the startling event or condition made while the declarant was under the stress of excitement that it caused. I'm going to skip that part. In the case at bar, most of the declarations made were present sense impressions. HJ located the unresponsive body of Xana Kernodle and informed BF and DM to call 911. HJ is Hunter, correct? EA was present at the time. All declarants personally perceived the event Kernodle unresponsive. The majority of the declarations were describing to dispatcher Carolina what they were perceiving. Those statements relate to Kernodle being passed out and not waking up. The declarations were made immediately after HJ discovered Kernodle's body. Didn't they see the blood? She was passed out and not waking up. They didn't assume she was already deceased because the wounds were brutal, right? I think her throat was like cut. So there was blood everywhere. There must have been everywhere. I'm curious about that. It is so heartbreaking. Against all logic, I agree. This is a pretty open and shut case. The evidence points at Bryan, but his defense is trying to get everything excluded because the detectives and prosecution focused on him rather than the chase leads. Hello, Lori. I'm glad you made it. Good to see you. And that was from number 7. Yeah. Some declarations made would be considered excited utterances. Those statements include, quote unquote, oh, and they saw some man in their house last night. Yeah. As well as the heavy breathing and crying that can be heard throughout the call. The declarants were responding to a startling occasion, discovery of the unresponsive roommate. The statement regarding a person being in the home is in direct response to why Kernodle might be passed out. All statements are made while the declarants are processing what has happened and were made before an opportunity to reflect and fabricate why Kernodle is unconscious. Clearly, the statement of BF, DM, EA, and HJ and the dispatcher, Carolina Calvin, fall within the hearsay rule exceptions. Judge John Judge has already ruled that the 911 call is not hearsay. And even if deemed hearsay, the exceptions for present sense impression and excited utterance apply. On August 23rd, 2023, defendant moved to dismiss the grand jury indictment. One basis for the motion was that the 911 call was improperly admitted hearsay, cumulative, irrelevant, and that the improper attempt to bolster witness testimony. In response, Judge John Judge held as follows. Further, even if the 911 call is hearsay, the exceptions for the present sense, impression, and excited utterance apply as the statements made by the callers, the surviving roommates. HJ and another friend who had arrived were made immediately after HJ discovered Miss Kernodle's body and instructed the roommates to call 911. The rationale justifying the present sense impression exception is that the immediacy of the statement offers no opportunity for fabrication. Finding statements made were excited utterances because the victim was still under the stress of the event. Sealed order denying motion to dismiss indictment on the grounds of the biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Regarding the quote-unquote emotion in the caller's voices, Judge further held that the evidence was relevant as to why law enforcement was sent to 1122 King Road on November 13th, 2022, as opposed to just EMS when the call was for an unconscious individual. This testimony was deemed relevant to the effect it had on the dispatcher, Calvin, and was not cumulative of Officer Noon's testimony. I do have to say, I know SW has done like maybe dispatch work. I'm not sure. I felt like the dispatcher was a little like I'm not sure if cold is the right word. And I know she was just trying to get the facts, but I feel like, I don't know, that just kind of made me feel some type of way. The statements made on the 911 call are admissible regardless of whether or not the witness testifies. Under IRE 803, present sense impressions and excited utterances are admissible whether or not the declarant is available as a witness. Any statement found outside of the above exceptions to hearsay are non-testimonial for the purpose of Crawford analysis. Based on the above cited authority, the state respectfully prays for the court's approval in limine of the admission of the recordings and transcripts of the 911 call to Whitcomb on November 13th, 2022, immediately following the discovery of Xana Kernodle's unresponsive at 1122 King Road. Exhibits. Oh, so these are sealed. Here we go. Oh, these are the exhibits. Dispatch says 911 location of your emergency. So this is basically the call. Hi, something is happening. Something happened in our house. We don't know what. We have, dispatcher says, what is the address of the emergency? 1122. No, don't. What is the rest of the address? Oh, Kings Road. And what is the house? Is that a house or an apartment? It's a house. Can you repeat the address to make sure that I have it right? I'll talk to you guys. We live at the right, so we're next to them. Dispatcher says, I need someone to repeat the address for verification. The address, 1122 King Road. And what's the phone number that you're calling from? What's your phone number? And then the rest is redacted. What's the rest? Dispatcher says, okay, and tell me exactly what is going on. One of the roommates who's passed out and she was drunk last night, she's not waking up. No, we saw ... Okay. Oh, and they saw some man in their house last night. Yeah. Hi. Are you with the patient? Okay, I need someone to keep the phone. Stop passing it around. Can I just tell you what happened pretty much? What dispatcher says, what is going on currently? Is someone passed out right now? I don't really know, but pretty much at 4 a.m. They don't finish their sentence again. Question, or dispatcher says, okay, I need to know what's going on right now. If someone is passed out, can you find that out? Y'all come on, we got to go check, but we have to. Is she passed out? She's passed out. What's wrong? Dispatcher says, dispatching Moscow Law Ambulance for, she's not waking up. Unconscious, 1122 King Road, 70 is en route. Okay, one moment, I'm getting help. Started that way. Okay, maybe. And then they can't tell what she was saying. All ambulances respond for unconsciousness, 1122 King Road. The dispatcher says multiple RPs on the phone, advice saying the roommate on scene is passed out and not waking up. Believe she got drunk last night, and the rest is unintelligible about a male being in the room with them. That one I copy about 20-year-old female unconscious trying to get further. Copy. Yeah, it's Evan. Okay, and how old is she? She's 20. 20, you said? Yes, 20. Here, do you want to talk to them? Okay, dispatcher says, okay. Hello, hello. Okay, I need someone to stop passing the phone because I've talked to 4 different people. Okay, sorry, they just gave me the phone. Is she breathing? Hello, is she breathing? No. Okay. En route. Bethany or Dylan, I need you to talking to them. Okay, I can't talk to them. I need you to talk to them. Okay, hello? Okay, I have already sent the ambulance and law enforcement. Stay on the line. Okay. If there is a defibrillator available, send someone to get it now and tell me when you have it. Units responding. The patient is unconscious, not breathing. The dispatcher says again, if there's a defibrillator available, someone get it now and tell me when you have it. No, we don't have one. Unconscious and not breathing. And that's when the cop arrives and she says, do you have a defibrillator? Yes, we have one. Are you talking to the officer? Yes, I'm going to let you go. And then the dispatcher says, I think we have a homicide. The transcript has been reviewed with the audio recording submitting and it is an accurate transcription. Hi, Jules. Hubby's a dispatcher. He says it was normal. I think she was rude and insensitive. I agree, SW. I really want to know what she would have said. I do too. Sadly, we may never know. Hello, Renee. The dispatcher was short. What if the perp was still at the house? I wonder if we're going to be able to hear the dad's, when she called her dad, what she told her dad, right? I think that's important because was it the dad that initiated them to call 911, right? It's wild. Help with life first, meaning if passed out, they will start CPR. That is why they do not care what happened earlier. Ah. Hey, eyes never lie. That does make sense, but it's unfortunate she wasn't able to say what she was going to say. I agree. Let's move on to the next document about the bushy eyebrows. Let me pull it up. And then we're going to watch a clip that of the new stuff that's out today. I know these documents are pretty much new too. This one's from February 24th, 2025, but I do have the new ones from a few days ago, so we'll try to get through those. Oh, my bad. Let's see. Bushy witness identification by bushy eyebrows. I don't know. I don't think the bushy eyebrow things should be legit because just because you have bushy eyebrows, I don't know. I don't know how I feel about that. Bryan Kohberger, by through his attorneys of record and pursuant to the Idaho rules, in limine moves in the honorable court in limine excluding any reference referring to the bushy eyebrows. More specifically, the defense asserts that the rule 601-602 of the Idaho Rules of Evidence Witness redacted herein DM from using the words bushy eyebrows or identifying Mr. Kohberger in that manner. Are the bushy eyebrows important here? I'm curious. I don't think so. I really don't. The issue of witness identification is a critical one in trial that is the subject of much litigation. That is because the reliability of witness identification is the linchpin in determining the admissibility of identification information. Failure to challenge unreliable witness identification can result in finding that trial's counsel performance was deficient and provided a basis for overturning the conviction. In this case, the description provided by DM is unreliable and should be excluded. Although she has never identified Mr. Kohberger, testimony by DM from the witness stand describing bushy eyebrows while Mr. Kohberger sits as the accused at trial will be as damning as her pointing to him and saying he is a man that did this. When considering whether identification by witness is reliable, the Idaho Supreme Court has applied Manson-Biggers balancing test, which looks at the opportunity of the witness to view the criminal at the time of the crime, the witness's degree of attention, the accuracy of the witness's prior description of the criminal, and the level of certainty demonstrated at the identification and the length of time between the crime and the identification. When the Manson-Biggers balancing test is applied to the facts of the case, the reliability of the witness identification is non-existent. DM is the only person alive who is known to have seen the intruder. She only saw the intruder briefly. Her recollection or lack thereof is filled with uncertainty, fuzziness, the influence of alcohol, dreaming, and sleepiness. She did not see the intruder well enough to describe him in a composite artist. After Mr. Kohberger was arrested, she did not recognize him from a photo. I didn't know that. I need to get that up. That's so weird. They can't say bushy eyebrows. Right, Tipsy. As an added descriptor, maybe. It's descriptive and not everyone has bushy eyebrows. Lends to DM's credibility. Homeboy's now waxing them things like if he was Daddy Yankee. Stop. Against all logic. Oh my gosh. I believe the 911 call was initiated due to potentially intoxicated subject, I assume. The preceded discovery of a homicidal scene. I heard he was like getting his eyebrows done now. Is that true? But honestly, I didn't know that she wasn't able to describe him in a composite artist to a composite artist, and she did not recognize him from a photo. Well, because he had a black mask on. I also wonder why her roommates would have a black mask on. I mean, what kind of prank is that, or whatever, etc., whatever the theories are, because I know my roommates wouldn't be doing that if I had them. Relevant facts. Bushy eyebrows. Interviews on November 13th, 2022. On November 13th, DM was inside the house when the murders occurred and saw a figure dressed in black, which is the intruder, when she peeked out of her bedroom door around 4 a.m. Shortly after seeing the intruder, she went downstairs to Redacted's room. The two girls fell asleep. Roughly 8 hours later, a 911 call was made from Redacted's phone at 11:56. More than 8 hours after seeing the intruder, DM was interviewed by law enforcement at the scene and at the police department. It was confusing to see Dylan, but the intruder looked at her but did not come towards her or say anything. I can agree with that. When describing the intruder to Officer Nunes at the scene, she described the height, build, and clothing of the intruder. Her description did not mention eyebrows. When she called Redacted before going downstairs to Redacted's room, not Bethany. Whose room? Is it Bethany's room? DM said that she was kind of in and out of it. I was really tired. Later, when she was interviewed at the police department, Detective 𝗟𝗡 inquired about facial features and asked DM if she knew what color the intruder's eyebrows were. She did not know the color of the intruder's eyebrows or eyes. Everything was kind of blurry, like I don't fully remember it. During the 𝗟𝗡 interview, DM again mentioned that she was in and out of it because she was so tired. He's plucking him with anything he can, right? If he shows up with them shaved off, then he is guilty. I wonder if DM underwent hypnosis soon after. Maybe she would have been able to recall her memory of that night more clearly. If she was in and out of it at this point in time when she's being interviewed, I'm not saying that we shouldn't believe her, it's not credible what she's saying, but I have a lot of questions. Pictures on November 13th, 2022. Law enforcement took pictures of Dylan's room on November 13th and November 19th. On the walls in her room were many pictures of eyes with prominent eyebrows, many of which she had drawn. Some of the eyebrows are heavy, voluminous, puffy, or perhaps subjectively bushy. According to Detective Lake, he found out artwork of human figures with emphasis upon the eyes and eyebrows were pinned to cork boards. Interview on November 17th. On November 17th, 4 days later, Dylan was interviewed by Detective G and indicated that she was really asleep and probably very drunk when she woke up around 4 a.m. on November 13th. Throughout the interview, DM expressed uncertainty about what she heard and saw and did not know if it was real or if it was a dream or if her mind was playing with her. It just doesn't make sense, quote unquote. DM described the intruder and told Detective G that she recalls seeing his eyebrows, his bushy eyebrows, but she did not recall the color of the eyebrows. She did not remember the eyes or the mouth, just the eyebrows. When she saw the intruder, she thought that the intruder was about 3 feet away from her, but that could be off since she was still a little bit drunk. She did not think she could remember enough to give a composite for a composite artist. She could just recall the bushy eyebrows, but not the shape or color of them. In this interview, Detective G asked if Dylan had any anxiety, which led to Dylan stating that she had a lot of lucid dreams of being kidnapped or chased. She indicated that she watched Criminal Minds and fell asleep to crime podcast. These lucid dreams began in high school. I didn't know that. Wow. Tired or drunk? SW, both. They were probably still drunk when they woke up, yeah? I mean, partying that hard. Forensic hypnosis is sometimes usually used in victims of traumatic crimes. Yeah, that's interesting you say that, because that sounds pretty cool. I know a lot of people do that for like trauma. Trauma really affects people differently. I agree, absolutely. It definitely does. Interview on December 1st. On December 1st, 2022, a half of a month later, Dylan was interviewed again and described the intruder. She did not see his eyes, but she saw one eyebrow or two, but it was just like this bushy eyebrow. I could just see like an eyebrow. This bushy eyebrow was what she said. She did not remember the color of the shape of the eyebrow. Wait, did I just read that? She did not remember if she saw one eyebrow or two. Throughout the interview, Dylan indicated that she always had really bad dreams, lucid dreams, and scary dreams. She did not know what part of her recollections were dreams and what parts were real. When she woke up that morning, the morning of November 13th, she did not fully understand what was a dream or not. In this interview, she indicated that she thought the person she saw was a fireman. We're going to read through that interview. Can we? I don't even know if that's out. She thought she saw a fireman? I mean, this is kind of wild. Statement and affidavit to support arrest warrant. On December 29, 2022, a statement submitted by law enforcement in support of the arrest warrant used descriptive information from Dylan's interviews. Dylan described the figure as 5'10" or taller male, not very muscular, but athletically built with bushy eyebrows. Damn, if our eyebrows are going to put us in the scene of a crime, y'all better get your eyebrows done today. Just kidding. One larger. I personally think the sorority had something to do with it. Interesting theory. A fireman dressed in black, right against all logic. And, you know, the fact that she can't remember, etc., a fireman, you know, I could see why this would be very controversial. Interview December 30th. On December 30th, after the arrest of Mr. Kohberger, Dylan was interviewed by Detective Lake and Detective Tolson. When she learned that an arrest had been made, she found a mugshot of Mr. Kohberger online. When asked if Mr. Kohberger was a person that she saw in the house, she did not know if Bryan was the intruder. She knew that the intruder had looked at her because of the bushy eyebrow. Just one eyebrow? I'm really confused. All that she remembered is some bushy eyebrow and all black and some sort of mask. Grand jury testimony on May 15th. Subsequently, Dylan provided grand jury testimony and was questioned about what the intruder was wearing. She was again uncertain, and the testimony is attached but not quoted verbatim here. The reliability of the witness identification. Firefighters do not wear all black, but emergency medical people do wear navy or black overalls. Firemen wear navy blue. Why would you guys have a roommate who wears a mask just for, like, why would she think her, I'm still stuck on that. I'm still stuck on a lot of things. Opportunity to view. Dylan peeked out her bed door three times after 4 a.m. on November 13th. The third time she saw a figure dressed in black. She peeked out her door 3 times after 4 a.m. So she was peeking out quite a few times. At the scene, she described the intruder as, quote unquote, he was a little bit taller than me and I couldn't really see much of him, but I'm almost positive he was wearing a full black outfit and he had this mask that was just over his forehead and over his mouth, and he didn't say anything to me, like, at all. At the police department, her description of the intruder was similar, and then I opened the door again and the guy is right there. And he's maybe my height, a few inches taller. Not like skinny athletic build. He has all black. He's wearing this mask that covers just his forehead here, and it goes like around. He was white. There were no lights on the stairs. Dylan was uncertain whether the kitchen light or the bathroom light was on. The kitchen light might have been on, but the twinkle lights in the living room may have been on. She opened the door and he was right there. Why didn't he kill her? Not that I'm saying, like, I'm just wondering why the intruder would let someone see him and he wouldn't do anything about it. I guess considering he just unalived 4 people. The degree of attention. Dylan acknowledged that her brain might have been fuzzy due to alcohol and sleepiness when she saw the intruder. She stated that she had been drinking alcohol just hours prior to peeking out her bedroom door sometime around 4 a.m. and seeing an intruder. She was intoxicated when she arrived home around 1:15 to 1:30. She was probably very drunk and tired when she saw the intruder at 4 a.m. Accuracy of the description. When asked if she could see the intruder's face, she testified, quote unquote, I wouldn't say I fully remember their face, but I remember seeing his eyebrows. So at some point, I probably did see his face and don't remember it. During other interviews, she said he was wearing a mask. So there's like one little piece of evidence, and then they have a lot of people saying that they don't know if it was actually Bryan. I could see why everyone's losing their mind about this case. Hey, gas mask. The college director childhood home was the address. I just don't believe in coincidence. He was very big with his boys' sorority. Unless he forgot a boot. Oh. If you live where it's cold, you might go running around. Yeah, I forget what those masks called that people wear in the winter. You know what I mean? Like, they're like almost snowboarding masks. Were drugs involved? Yeah, alcohol. Why so focused on eyebrows? I know. I kind of feel that way too. It can look black because it's dark, right? And the shadows, and who knows? You're drunk, so then there would be lights from the responding trucks. Maybe BK was in a trance. I mean, he is crazy. Visual snow, he didn't see her. He was at the door, right? She said he opened the door and he was right there. So they clearly saw each other and had eye contact and eyebrow contact. Level of certainty. During each interview, Dylan was uncertain. On December 30th, 2022, after the arrest of Bryan, Dylan was interviewed by Detective Lake and Detective Tolson. When she learned that an arrest had been made, she found a mugshot of Mr. Kohberger online. When asked if Mr. Kohberger was a person that she saw in the house, she did not know if he was the intruder. She knew that the man had looked at her because of the bushy eyebrow. Why just one? All that she remembered is some bushy eyebrow an all black and some sort of mask. Several weeks after the murders, Dylan thought that the person she saw was a fireman. In her mind, Dylan thought that the intruder went out of the back sliding door, but she doesn't know if he actually went out the back door. The sliding black door was not visible from the doorway of Dylan's bedroom. Time between the event and the identification. At approximately 4:00 a.m. on November 13, 2022, DM saw the intruder. Roughly 8 hours later, the 911 call was made. 8 hours later? Again, I'm stuck on the whole when they saw the Kernodle. Was it Kernodle? Yeah. And she was not breathing. Where didn't they see the blood? They would have assumed she was deceased. Right? There was blood like dripping through the walls on the outside. I'm really shook, like, oh, because they weren't in the room, right? I think Hunter was the only one that saw them. We're going to play a clip about that in a second. Roughly 8 hours later, the 911 call was made. More than 8 hours after seeing the intruder, Dylan provided a very limited and uncertain description of the intruder to 2 different officers. On November 17, 2022, 4 days later, Dylan did not think she could sufficiently describe the intruder for a composite artist. On December 30th, 2022, after Kohberger's arrest, Dylan could not recognize him from a photo. Further, by the time that Dylan testifies at trial later this year, more than 3.5 years later will have passed since the murders occurred on November 13th. 3 years already? I'm shook. Hey, not that chicken nugget, good to see you. Visual snow causes peripheral issues with vision. This case is wild. It is so wild. Let me know. What do you think about all of this? The him standing at the door, the one eyebrow. Many of you said Bryan is guilty. Who thinks Bryan is innocent? I'm curious. All opinions are welcome. Or did he put the 𝗟𝗶𝗸𝗲 knife away already and did not want to deviate from his plan? Remember, he has OCD. He most have likely had planned everything out. Yeah. Hey, Jules. Yes, I am very much looking forward to this trial. She's one very lucky girl for him to see her and just walk away right by her after what happened. Yeah, I feel like murderers generally, or serial killers, probably would get rid of their witnesses, right? But the 911 call is just heartbreaking. They made that boy walk in a bloodbath. Yeah, we're going to play a clip from one of the parents talking about that roommate that experienced that. Hey, MJ. B. Suspect was wearing a balaclava. With any major crime, the timeline is important. The 911 call played earlier supposedly preceded the crime scene discovery, as had been acknowledged by authorities. Nah, he did it. I think the white snow theory is spot on. Argument. While certain exceptions, every person is competent to be a witness. Incompetency determined by the court occurs when, quote unquote, persons whom the court finds are incapable of receiving just impressions of the facts about which they are examined or of relating them accurately. Idaho law tends to favor the finding of competency. Under Idaho Rule 602, a witness might have sufficient personal knowledge of the matter to which he or she is testifying. Testimony satisfies if the jury or other trier of fact could reasonably find that the witness perceived the event. Evidence to prove personal knowledge may consist of the witness testimony. So it says the fact could reasonably find that the witness perceived the event. So did she really perceive the event and she was drunk and still drunk in the morning? I'm curious. If you're driving, get a DUI, they're not going to be like, oh, you don't remember, it didn't happen, right? So you're still going to get in trouble for that. So I just feel like if she doesn't remember all the facts, should he really be guilty? When considering whether identification by witnesses is reliable, the Idaho Supreme Court has applied the Manson balancing test, which looks at the opportunity of the witness's degree of attention, the accuracy of the witness's prior description, the level of certainty demonstrated at the identification, and the length of time between the crime and the identification. When the Manson, I'm sorry, I said that wrong earlier. When the Manson-Biggers balancing test is applied to the facts of this case, there is no reliable witness identification. As explained in detail above, DM's opportunity to view was seconds at most. Her attention was influenced by alcohol and sleepiness, and the only identifying attributes are height in relation to her own. A skinny, athletic build and a bushy eyebrow. He was wearing a mask. She has repeatedly, each time interviewed, expressed uncertainty about what she saw. These general descriptors could fit millions of individuals. Her uncertainty is repeated in each interview, and at least 8 hours passed before she interviewed the first time. I mean, it goes back to basically what I was just saying. 6 weeks passed before she was interviewed by law enforcement the final time, and 6 months passed when she testified before the grand jury. Balancing the Manson-Biggers factors, there's no reliability of the physical characteristics that Dylan has reported. Mr. Kohberger does not have bushy eyebrows, but the artwork on Dylan's wall and that which she should draw eyes with eyebrows could be described as bushy, full, or prominent. There's a great risk that at trial in front of a jury, her testimony will be viewed as a clear identification of Mr. Kohberger. This would be a false identification and would prejudice the proceedings in a way that must be avoided. I'm shook. I'm shook. Sorry, that video is playing in the background. The video that I'm going to play next. Sorry, my bad. I don't know if you guys can hear that, but and Taylor will eat the survivors alive in this trial. Nah, he has bushy eyebrows. They were in bed, yes, but awake. Dylan protected his girlfriend. They all had defensive wounds as this was not a one-person kill. I agree with that, unless they were trained. Okay, I was talking to someone about this today. I agree with that. From the beginning of this case, I didn't think that it was a one-person thing. But if that's the case, why is Bryan not bringing anyone else up? Since he's looking at the death penalty, right? I would be surprised if VK is found not guilty with what little we know. I feel like he is guilty. I know the prosecution has so much more, and I cannot wait for the case to start. I do think there's so much more, and we're just getting like bits and pieces of it. That happened with the Stearns case, right? We weren't getting anything, and now we're getting all these calls. Make sure you watch that live too. I did on all the calls. He is the fall guy, unfortunately. Those he killed were asleep, taking away some of their humanness. Seeing an individual might have humanized them, making it difficult to kill them. I don't know. Bryan has a damn good lawyer. It's going to be a court case you don't want to miss for sure. Yeah, we're definitely covering that for sure. Defense is arguing the FBI tampered with evidence. The problem is Bryan wanted to be like so much. I think he got himself involved with the wrong kids. Hey, Britt, good to see you. Good opinions. So Rule 403 excludes evidence of the bushy eyebrows as irrelevant and unfairly prejudicial. To be admissible, evidence must be relevant. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And the fact is of consequence in determining the action. Whether a fact is of consequence or material is determined by its relationship to the legal theories presented by the parties. In this case, the evidence of bushy eyebrows is not relevant to the crimes charged and would not tend to make any material or disputed fact of the crimes charged in case more probable or less probable than it would be without the evidence. The purpose of admitting such testimony is for identification purposes. Given the arguments above, such testimony is inadmissible. There is no other relevant reason to allow this testimony. Under Idaho rule, this court may exclude evidence related to bushy eyebrows if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. This rule requires the court to balance the probative value of the evidence against the danger that the evidence may be unfairly prejudicial. Even assuming this court concludes that the descriptive words bushy eyebrows are somehow relevant, whatever minimal probative value they have they may have is substantially outweighed by the danger of the unfair prejudice and confusion of the issues. Unfair prejudice is a prejudice that tends to suggest a decision on improper basis. I'm learning so much through these documents. DM could not recall enough details about the intruder to provide a description to a composite artist. Allowing her to use the descriptive words bushy eyebrows confuses the issue. If the evidence of bushy eyebrows is presented to the jury might well believe that Mr. Kohberger is guilty simply because of the bushy eyebrows. As a consequence, there's danger that the jury would reach a decision on an improper basis due to the evidence that is fairly unprejudicial. For reasons addressed above, Bryan respectfully requests that this court grant his motions in limine to exclude Dylan from using the words bushy eyebrows to identify the intruder that she saw, and to exclude Dylan from identifying him based on the bushy eyebrows. That is super wild. These kids have very powerful dads. The college kids is what you mean? Let me pull up. This is Bryan. I know you guys already know, and I know I already showed you guys. Oh, there we go. There he is. What's up with the thumbs up? Like, I know there's so much about like the shower curtain, and this was right after, right? Allegedly right after the murders. I don't know how I feel about this picture again. Okay, I'm going to play a clip, and then we're going to move on to the documents filed this week. Ooh, one of them is really long. We might save that one for the end. Anyways, that's fine. A vampire, dude, does he sparkle? Let's see. Oh, let me play that clip. I have 3 documents filed this week, which is wild. There was so much more filed today too, but I wanted to get caught up with y'all if you haven't. I know there's a lot of videos and shorts, but I like reading the court documents. It does give vampire a bit creepy. Okay, I want to play this interview. Her dad, one of the dads is in there. Goncalves' dad, Steve. A vampiro, right. Okay, here we go. This is just a 5-minute clip, but I thought it was so good.
Word, and my wife has said from the very beginning, when the hopefully the 911 never came out, and if it did come out, at least she would have, be some prepared. She has a counselor, she has people she could talk to. There's certain things that coping mechanisms. So we'd like for the advocate or somebody to kind of let us know what's going on, rather than nothing personal, but having the media tell you is probably not the same as having somebody that, that you've learned to have a relationship and you trust and you've worked with. So yeah, we're finding out just like everyone else. So it's a bit rough.
Yeah, I'm so sorry. And I remember that you had a meeting with them months ago, and I thought they were going to sort of give you guys a heads up when things were going to be released publicly. And I guess that didn't happen in this case, which is unfortunate. Is there anything, Steve, that, I mean, obviously the horror is what stands out to me, but was there anything in the text of the text messages or the call that really struck you?
What struck me is, it's not like Hollywood. It's not a scripted thing. It's not like what you would see on a TV set. That was a raw, emotional breakdown of 2 girls that were scared for their life. There's part of me that knows that, like how that house was, there's a lot of pranking going on. There's a lot of partying. So there's part of them that was probably thinking, is this a prank? Am I getting messed with? I know for a fact my daughter loved pranking people. So my heart goes out to those 2 girls. I'd have a hard time if I was one of their parents to have my daughter put through what they've been put through. I mean, we sat 2.5 years on what? You know, why did this need to be hidden from the public? Why did these girls have to be dragged through all this? These are the type of things that why I do these interviews and why we push back a little bit, because I think a lot of people are questioning right now why this was hidden.
Yeah, I mean, look, Shannon, it's been years and none of this is coming out until now. And now the judge has said that he wants more of this to become public. But Steve makes a good point. I mean, if this had just come out within the first couple of months, maybe it would have been easier on the survivors and the victims' families like the Goncalves.
Yeah, I mean, you know, the prosecution's choice in keeping everything under wraps has been a decision that they've made from the get-go. They haven't wavered from it in any way. That being said, you know, I mean, for lack of a better term, I'm just pissed. You know, common decency should have that the Latah County prosecutor's office and the victims' advocates contact myself and the victims' families and let them know some of the stuff that's coming down and is being filed. So they're not just surprised by it, and just have a really just honest conversation with us about it. But none of that happens. And I'm frustrated and I'm pissed for myself and the family that I don't have a chance to explain those things to them, to give them a little bit of a heads up on, hey, these motions are filed this way and they may or may not be successful. If it is successful, who cares? You know, doesn't affect the case in some way, or my opinion on whether or not those motions might be filed or might be successful or not. But it's just really, really frustrating. And I know Steve and Christy are frustrated by it, but I'm the one that gets to say, you know, I'm pissed, and I'm pissed for everybody. So.
Yeah, and I mean, even if they can't give you the documents ahead of time, it seems like they could at least give you a heads up to tell the family, hey, you know, maybe don't watch the news for an hour. Give me a second to go through these and call you. And, you know, it seems like that would be a sort of a decent thing to do. Steve, what do you make of this latest motion where they're trying to ban words from coming out during trial? I mean, simple words like that are part of the case: murder, bushy eyebrows, sociopath, psychopath. Did this come as a surprise, Steve?
Yeah, I thought they'd have a sadistic on there from the profile that I know that they've made of him. Some of the websites that he's been to, that was a one that rated really high with him. So I'm a little surprised they didn't put that word on there. But when you're super desperate, you really have nothing, you know, you attack words and simple things like that. I mean, they're really done. I mean, their client has left so much evidence that they've got to attack words. So I guess it's a sign. It's a sign of what's to come. And hopefully the state and prosecution strong enough to see this all the way through and not give in to the desperation that's about to come and the plea deals that they're going to try to negotiate for.
Thanks for watching.
Shout out to News Nation. I do love them. Let's watch one more short one. We're on the dad.
Now is Kaylee's father, Steve Goncalves.
Oh, my bad.
Steve, thank you so much for joining Top Story. And I also want to say I'm so sorry that you have to join us and that we have to speak like this. I know you were doing this to speak for your daughter, but I am so sorry this is a situation you find yourself in at all. I want to start with just asking you about that selfie that everyone has now seen. What went through your head? What did it feel like when you saw that selfie of Bryan Kohberger allegedly taken hours after your daughter and her housemates were murdered?
It was a trophy. He made himself a trophy. He felt like at that point he had just returned from the crime scene. There was no one there. And he believed, very confident, that's what the thumbs up. He's going to look back at that, remember what he got away with. And, you know, it's a challenge to Idaho to let everybody know that, you know, he thought he could kill people in our state, get away with it. He was far smarter than everyone else around him. And he studied it. He's trying to be a PhD in it. So I think it was a challenge to Idaho, and I think Idaho will definitely step up, and he's going to regret that photo.
Steve, I want to also ask you about one of the requests the defense is making to the judge, asking that they do not allow spectators to wear T-shirts with pictures of the victims on them or anything like words in the memory of. How does that make you feel?
It's petty. I don't worry about it, though. My daughter's, justice and getting this conviction is much more important than wearing a shirt. I've never worn a shirt in court. They'll never be able to ever show that I ever did. So, when you got somebody facing, death row, you probably should focus more on, the case and the evidence rather than who's going to be in there witnessing it.
The defense has also claimed that they're going to present alternate perpetrators. Do you believe there is anyone else involved in the murder of your daughter
We talked about
and
this.
her housemates?
No, not at all. There's surveillance all around there. You're going to clearly see who was coming into the place and exactly when they were leaving and what that vehicle looked like when it took that corner. This case is solid. It's super solid, and we look forward to it. They're just trying to delay it, but it's time to pay the piper. We're all going to see what the state has, and I'm very confident in what they have.
How is your family holding up and handling all of this? I mean, last week we heard the 911 call partially released. We've seen this selfie now. What is it like for you and your family to keep having these items, these bits of information come out?
It is hard. It's very hard. You kind of just prepare your family, tell them to stay away from the TV, stay away from, parts of the internet. So, but it's nice to get this information out. It's good to see the facts. I mean, it's weird to wait 2.5 years to know like some of the final things that, your child has been through. We're still waiting on even like laptops and things that, so we can see, her playlist and things that she was working on. It's tough. It's tough to go through this, but, I just think of all the officers and, the FBI agents and all the hard work that they put into this. So, I can wait and, we can get this out. We can figure it out.
As we move closer to seeing Bryan Kohberger actually face a jury and answer to these charges, what for you and your family is the thing you hope people focus on the most when that coverage really gets in full swing? What is it you hope people don't forget about what y'all have experienced or about your daughter?
I think if people can concentrate on how much victims they were, how these people were just going through their everyday life, trying to be educated, try to be like the best type of human being that you could possibly be. And even having all the way from like their meals that they shared together till their Uber ride, they weren't drinking and driving, they weren't doing anything bad, and come home and to go to your bed and to have some stranger that he's not even a part of our state. He just didn't even belong here, and to have that person sneak into your home and kill you in your bed. If there wasn't ever a moment for people to rally together and say, it's time to take this to the full closure and have a message that's out there so we can kind of point to say, we put our foot down right here. And, when we have these school shooters and people that do these mass murders, maybe we have to start putting our foot down and taking it to the darkest part, all the way till we finalize these people. And then maybe we can stop having these so often.
Have you been able to speak to any of the other families, Ethan's family, Xana's or Maddie's?
Yeah, I've spoken to all the families, some more than others, but yeah, I mean, Karen she'll call us in the middle of the night, so we know if you're struggling, you're having a hard day, that you picked up that phone and you spend some time talking to somebody. Mm-hmm. And I love talking about Maddie all the time, so it's pretty easy for us to do.
Are you and the other families confident right now that prosecutors have what they need to get a conviction here?
Yeah. They broke that down early on, and they basically outlined a couple different scenarios. And one of those was, hopefully this person comes out and says that he was framed. Was ideal, because that basically just means there's so much evidence that he just can't combat it. We didn't think we'd get as lucky as no alibi. We thought he'd think it out, and he is a smart guy. I figured he'd have some better way to explain what he was doing that night. I mean, I could think of a lot of better ways he could have done it. Really tricky stuff, but he didn't. And luckily, the case is going to be, it's going to be handled, and we'll get the eventual. We'll never get our kids back. I take that over any of this, but this is the best that we can make of the situation that we're in.
Steve Gonzalez, thank you so much for joining us. And I promise you, we will remember Ethan, Kaylee, Xana, and Maddie as we move forward covering whatever happens next with this trial. We appreciate your time tonight.
I don't know how they do it. The parents, I mean, oh my gosh. I don't know. Okay, I'm pulling up the next document, and then we'll have one more clip, and then we'll continue on Bryan Kohberger this weekend. I have another True Crime Live tomorrow on a new case that I need to report on. We're on CCTV practically, yes. Learning the laws and being able to kill 4 people in 2 separate rooms is crazy work. Somebody got in there and killed 4 people, and that's not on camera. Yeah, it's got to be rough. It's got to be so rough. Okay, so this document is the state's response to the motion in limine about the bushy eyebrows. I don't know if we should read the facts. We kind of already know, but let's just get through them. I don't want to miss anything. On November 13th, sometime before 4:19 a.m., Dylan observed a person inside her residence, which she shared with her 4 roommates at 1122 King Road. DM placed several phone calls and sent several text messages to her roommate. The only roommate who responded is BF. They have 2 short conversations, 24 seconds and 41 seconds. Within those phone calls and text messages, DM relayed to BF she saw a person in the residence wearing black, and he had a ski mask on that covered his forehead and mouth. Wait, covered his forehead and mouth? How did they see the bushy eyebrow? On November 13th at approximately 11:56 a.m., a 911 call was placed from 1122 King Road for a reported unresponsive female. The caller stated that one of the roommates was not waking up. The caller stated, oh, and they saw some man in their house last night. Moscow Police Department responded to the scene. The same day at approximately 12:09 p.m., Moscow Police Officer Mitch took a statement from Dylan on the scene outside of King Road. Dylan told officer she saw a male not insanely tall, wearing all black and a mask that was just covering his forehead and mouth. Later, Dylan repeated the description. He was a little bit taller than me. I couldn't really see much of him, and I'm almost positive he's wearing a full black outfit, and he had this mask that was just covered, that was over his forehead and his mouth. DM gave the description a 3rd time, repeating he had a mask. He was an inch or 2 taller than her. He was a basketball player, kind of skinny, of a voice she did not recognize. That day at approximately 1:47 p.m., Dylan was interviewed at the Moscow Police Department by Detective 𝗟𝗟. During this interview, Dylan reported that she saw a white male, but she did not know maybe my height or a few inches taller, skinny, athletic built, wearing all black. Regarding his height, she reported, I'm 5'10", so he's probably around 6 feet. She reported, I don't remember his eyes, what his eyes look like either. I didn't recognize his eyes, but definitely a white guy. 4 days later, on November 17th, DM was interviewed by Idaho State Police, Detective G, which we already covered in the previous document, and Dustin Blaker. Dylan gave a detailed recounting of what she did on Saturday, November 12th, until she went to bed at approximately 3:20 a.m. on Sunday, November 13th. Defendant's Exhibit number 6, pages 19 through 50. Sometime between 4 a.m. and 4:20, Dylan woke up and heard a male's voice, a voice she did not recognize. Says, it's okay, I'm going to help you. I also was curious about that. It's okay, I'm going to help you. DM opened the door and saw, quote unquote, someone, because it's from my mind, it's like I was almost wearing these like blurry glasses, like it's fuzzy and cloudy, but it was like a figure of someone wearing all black. And it was like they had a ski mask that was covering their forehead and their chin and mouth. But I could see all I remember was seeing their eyebrows. And I don't remember what the eyes look like, but I remember their eyebrows. I just don't remember the color of the eyebrows. I remember they were bushy eyebrows. That's all I could think about. Dylan described the male as a not skinny tone, that kind of that basketball kind of type. Dylan states that she's 5'10" tall, 5 feet 10 inches tall, so thought that the male was around 5'10" and then 6 feet, somewhere around there. Dylan stated the male was approximately 3 feet from where she was standing. I would say about 3 feet from what I remember. Again, that could be off because I obviously probably still a little bit drunk. I just woke up. I don't fully remember. Again, she described the male. I know he looked at me because I could see his eyebrows. I think I just saw one eyebrow. I don't know why or how. Dylan recounted calling and texting her roommate BF, and she discussed with BF that there was someone in the house wearing all black and a ski mask. Dylan conveyed to the interviews that the facts didn't fully make sense to her and she didn't know how to explain everything. Detective G explained to Dylan that the important thing was to tell only things she knew were true. That's the most important. Detective G acknowledged Dylan's trauma. Detective G and Blaker confirmed the facts from Dylan's memory again. Dylan reiterated she saw a male figure in the hallway approximately 3 feet from her. He was holding something. He was wearing all black clothes. His forehead was covered. He was wearing a mask. She remembered his eyebrows. Blaker asked what was covering his face, and Dylan stated, I don't know. Weird looking ski mask. It wasn't like the regular ski mask with like eyes and, because I saw his eyebrows and I think I saw his nose and like that part of his face, but I don't know. Detective G asked Dylan if she knew what a balaclava was and showed her a picture. In response and addressing whether she could see the male's mouth, Dylan stated, quote unquote, no. And I don't remember if I saw it. Like, I don't remember if I saw his nose, but I know I saw eyebrows. And I don't remember his eyes. I just feel like I can see eyebrows. But I mean, that could be it. I mean, that would make sense. Why the forehead was covered and this part of his face was covered. The investigators inquired if Dylan could provide a composite for an artist. Dylan responded, no, I don't remember what his eyes look like. I don't remember what his nose looked like. I just remember eyebrows. I don't know exactly what the eyebrows look like at all, really. I just remember thinking like eyebrows. Yeah, bushy. That's all. Like, I don't remember the shape. I don't remember like the color. I just remember like bushy eyebrows. That's the only thing I can remember. Let me see what you guys are saying. That's got to be rough. Good to see you, Spog Dog. Hey, Doofast, good to see you. She's 5'10". That's pretty tall. It is. Bushy eyebrows. Unibrow stalking. She was 3 feet from death. Right, SW. Right. Hi, Holly. Good to see you. I'm glad you made it. If she heard a voice, then why would she not be able to hear the voice again and recognize it? There's just too many holes, and I believe Anne's going to poke holes. It all seems circumstantial. How terrifying to be that close to him. Right, Tipsy. On December 1st, 2022, 18 days after the first interview, Dylan was interviewed by forensic interviewer Aaron Williamson. Dylan gave a detailed accounting of Saturday, November 12th, until she went to bed on Sunday, November 13th. Defendant's Exhibit number 7 of the transcript, which were not included in the defendant's exhibit, DM reported that she heard a man's voice and it wasn't Ethan's. It was like, quote unquote, it's okay, I'm going to help you. Dylan stated she saw an all-black figure about my height, maybe a few inches taller, skinny build, wearing a mask. Dylan described, I don't remember if it was just like one eyebrow or two, but it was a bushy eyebrow. DM texted BF, there's a tall guy in all black. Again, Dylan described the ski mask. I couldn't see any of his hair, but I remember just like seeing, it was like almost rectangular, not like the circle ones. It was rectangular because I remember seeing like, just like, I don't know how to explain it, just seeing like this, maybe I'd be able to see like a cross, but I don't remember seeing his eyes. But I feel like his eyes were there. I could just feel like an eyebrow. I feel like that's how I know he saw me, because I could see his eyebrow. Like if I could see his eyebrow, he can see me. From what I remember, I think he was just like walking past that little wall and going towards the kitchen. And I don't know, like I just remember seeing an eyebrow, and I don't know why I just see one. It was just like one bushy eyebrow. I don't remember the color, like the full shape. I just remember it being bushy. She described his clothing again, stating that the male was wearing black long sleeves, black pants, and black boots. At the end of the interview, DM drew the mask for the interviewer. While drawing, she gave a consistent description of the mask and noted the eyebrows. I don't remember if I saw one or two. Like, it was just weird. On December 29, 2022, Bryan was arrested in Albright, Pennsylvania. The following day, on December 30th, 47 days after his first interview, Dylan was interviewed by Idaho State Police, Detectives Joe Lake and Gary Tolson in Idaho, in Kohberger, Idaho. Defendant's Exhibit Number 9, Dylan was asked about Bryan Kohberger. Dylan was asked, have you seen a picture of Mr. Kohberger? Dylan responds, yeah, I looked him up today when I found out. Regarding what picture she saw, she stated, I've seen the mugshot one with the best thing, I think. The interviewer asked, this Bryan Kohberger, the person that you saw in the mugshot, is that the person you saw in your house? Dylan responds, I have no clue. From what I remember, I just remember seeing this figure that was like not fat, obviously, but more of like a skinnier tone build and some mask on. I don't know what the mask was exactly, but when I thought about it, it was just like covering here and here. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember knowing he was white, but I didn't know how he was white. I just knew he was. And this, knowing there's, like, I know he had looked at me because of the bushy eyebrow. That's all I remember. But I have no idea what he looked like. I don't like, when I looked at this picture, nothing came back to me at all. So that, like, I don't know. I feel like if I saw him, my mind would be like, oh yeah, that's him. But it just, I don't remember at all. Regarding Dylan telling BF the male had a big nose, Dylan states, all I remember, but I don't remember big nose at all. Like at all. That's like, all I remember is like some bushy eyebrow and all black and some sort of mask. But it wasn't like one of those circle ski masks. That's all I remember. Wow, they're really like honing in on the eyebrow, the one eyebrow. Absolutely terrifying, but I don't think that's what happened. Those girls are involved, in my opinion. Interesting. On May 15th, 2023, 183 days after Dylan's first interview, Dylan testified at the grand jury proceeding for the above titled matter. Regarding November 13th, 2022, Dylan testified she woke up around 4 a.m. to noises, music, Murphy talking, and or singing. Dylan testified she opened the door and heard a man's voice say, quote unquote, it's okay, I'm going to help you. And I didn't know who the man's voice was. Dylan testified she opened her door again and saw, quote unquote, a figure in all black, which I believe was a person. I knew the person was white. I don't know how, but I just knew it was a male. I think I knew because of the voice. The person was around my height, a few inches taller. And then I knew his build wasn't like scrawny, but he wasn't fat. So I figured it was like basketball toned, lean build. Regarding what the person was wearing, Dylan testifies, there was like, from what I remember, it was all black mask, almost like a ski mask, but not. It just covered the head, maybe up to the mouth, maybe more. I can't remember if it just covered the chin, the mouth, or the nose, or lower. I mean, I empathize with them, but she don't remember a lot, right? And I'm so curious what you guys think about the it's okay, I'm going to help you. Like, what was that all about, in your opinion? Dylan testified that the clothing was all black. She testified, well, the thing I can remember was something about a bushy eyebrow. I don't remember seeing anything else, just something about a bushy eyebrow. The argument is that Dylan's statements are independently reliable as law enforcement did not employ a witness identification procedure triggering a Manson-Biggers balancing test. The case relied upon the defendant deal with the witness identifications that result from the use of law enforcement identification techniques. The fact of each of these cited cases are important because they differ vastly from the facts in the case at hand. I'm going to skip the references to the other cases. This process did not result in identification. Okay, that was regarding the other case. The United States Supreme Court has held the due process requires the exclusion of identification evidence if police suggestiveness creates the substantial risk of mistaken identification. The Supreme Court, the reliability factors to be employed after a witness identification are as follows. The opportunity of the witness to view the criminal at the time of the crime, the witness's degree of attention, the accuracy of his prior description of the criminal, the level of certainty demonstrated at the identification, and the length of time between the crime and the identification. If there are aspects of reliability evidence from the factors that substantially outweigh the corrupting effect of suggestive identification, then the identification testimony will be admissible. In each of the above cited cases, law enforcement employed identification procedures that were arguably suggestible. As a result, it was necessary for the court to employ the Manson-Biggers balancing test to determine if the witness's identification were reliable or instead impermissibly tainted by suggestions that would lead to misidentification. The facts of the Kohberger case are vastly different from the cases relied upon by the defendant. In the case at hand, on 4 separate occasions, prior to Bryan being arrested, Dylan gave consistent descriptions of the male she saw on 1122 King Road residence around 4 a.m. Dylan gave the following consistent descriptions: white, male, wearing all black, a few inches taller than DM, wearing a mask, skinny, athletic build, toned, not a voice she recognized. During 3 of those interviews, DM also consistently describes the male's eyebrows. 5 times, Dylan uses the term bushy to describe the eyebrows. Regarding identification after Bryan Kohberger was arrested, Dylan was interviewed. She relayed that she saw a mugshot of Bryan on the internet. Detective Lake asked Dylan, "Is this Bryan Kohberger, the person you saw in the mugshot? Is that the person you saw in your house?" And she replied, "I have no clue." She relayed to Detective Lake that the person she saw had a mask on that covered his mouth and nose. The only discernible features were the subject was white and had bushy eyebrows. This questioning of DM is not a witness identification. There was no law enforcement procedure employed to suggest identification. Most importantly, there was no identification by DM. DM's multiple descriptions of the male were based on her own recollection and were not the result of suggestive identification procedures employed by law enforcement. 2, even if the court applies the Manson-Biggers test, the totality of the circumstances presented in this case substantially outweigh any suggestive present. Even if the court employs this balancing test to the facts of this case, the court should find that Dylan's description, including bushy eyebrows, are reliable and admissible. First, regarding opportunity to view Dylan, she stated she was only approximately 3 feet from the male when she saw him. Dylan was able to get enough of a view of the male to determine his outfit and the details regarding the mask he was wearing. Dylan also determined the male was holding an item, although she was not able to determine what item was on. I'm going to deep dive this real hard because I'm curious to get all the information on like the social media stuff that was going on, like him following them on Instagram and all of those things, right? Let me go back because I'm missing some really good comments and I don't like to. Hi, Widow. I'm glad you're back. I don't know. I just think if I felt comfortable enough to fall asleep, I surely wouldn't be afraid to go check on my friends. That's a good point. Tipsy says, all I can think about is maybe they were so used to having people in and out of the house, she didn't think it was a danger because it was a party house, right? We know that. Hello, Tony. Good to see you, lovely. I agree with that. I agree with a lot of what you guys are saying. If that was true, she wouldn't have texted B about being afraid. Remember, they had a whole combo before she ran downstairs. Yeah, the whole 8 hours, like a lot of it, this seems like shifty to me, but I don't blame them. They were drunk. It was a night partying, right? Like, we don't know. We all weren't there at the end of the day. We really weren't. D texted B when this was going on, supposedly, right? It is very strange. I wish she would have called for help and that none of this ever happened. I agree, Tipsy. I'm sure they didn't even comprehend what was happening. Never mind a homestead. I know, right? Like, you don't, when you're partying, you don't just think, oh God, I'm going to find my roommates with their throats slits, right? Like, I get that too, Holly. SK was crazy not to let out of the house full of people. Right. Hello, Whittle. I agree. The 8 hours is strange. Yeah. Okay, let's get back to this. Second, regarding degree of attention, Dylan's statements indicate during the time of her observation, she was only able to see the eye and nose area. This means the only discernible features on the male would have been the nose and eyes. On November 17th, DM states, I just remember bushy eyebrows. That's all I could think about. Defendant notes Dylan's artwork and drawings found on her bedroom wall, which focus on the eyebrows and eyes. This only proves that Dylan would have a degree of attention to this facial characteristic, thus reinforcing her reliability. Defendant states that Bryan does not have bushy eyebrows. The state intends to introduce a photograph of Bryan Kohberger taken from his phone November 13th, only hours after the homicides at 10:31 a.m. We saw that picture. Whether or not Bryan Kohberger can be described as having bushy eyebrows is a factual determination to be decided by the jury. I wanted to go back. Oh, the art thing. I don't think that should be, I don't know. In my opinion, I don't think that the bushy eyebrows should play a role, and I don't think that her artwork should also play a role. But I guess that's what they have ongoing, other than the sheath, right? The evidence, the DNA. Third, regarding the accuracy of the description, Kohberger matches Dylan's description. Male, white, skinny, athletic build, a few inches taller than Dylan, not someone she knew with bushy eyebrows. Fourth, regarding the level of certainty, Dylan texted BF a description immediately after her observation. She was interviewed on 5 separate occasions, and she provided grand jury testimony. Dylan, without fail, gave the same description, which in of itself indicates her level of certainty. On November 17, 2023, she relayed to instigators she was suffering from trauma and was unsure of what is real or not. Dylan admitted many times she was probably still intoxicated. Quote unquote, I don't know if I was still drunk. Probably was. I don't know for sure. I was really asleep. I woke up out of nowhere, and I was obviously probably still a little bit drunk. I just woke up. I don't remember fully. Admittedly, Dylan made such statements as, I believe I was also very drunk. I don't know how much of this was real. I don't know if my mind was doing whatever. I don't know any of it. Half of the stuff, I don't know if it's a dream or it's real. I just have no clue. That could also be the trauma, right? She was blacked out drunk pretty much. And then the trauma affecting her. But the investigators told Dylan they only wanted Dylan to focus on what she knew was true, which was the most important. Dylan agreed. After this, Dylan provided the same descriptions with absolutely no variance. Dylan also made it clear the eyebrows are the feature she most clearly remembered. It is evident by the degree of detail she provided about the events leading up, during, and after the crimes that she provided reliable descriptions. Lastly, regarding the length of time between the crime and identification, while there are multiple consistent descriptions, it was not possible for DM to provide an identification because the male was completely covered with only nose and eyes visible. After weighing the above factors, the court should hold that under the totality of the circumstances, Dylan's descriptions of the male, especially the bushy eyebrows, are reliable and admissible. Dylan's statements are relevant and admissible. Under Evidence Rule 401, evidence is relevant if it has a tendency to make a fact more or less probable than it would be without evidence, and the fact is of consequence in determining the action. Defendant argues the evidence of bushy eyebrows is not relevant. That is not the case. Dylan is the only living person who saw the person responsible for the 4 homicides at 1122 King Road on November 13th. Her description of the individual, including characteristics such as bushy eyebrows, has the tendency to make a fact more probable than it would be without the evidence. This fact is of consequence to determining whether Bryan Kohberger was the same male that Dylan saw that night. The person responsible for the homicides, the central question before the jury. This evidence is relevant. Defendant then argues this relevant evidence should be excluded because its probative value is substantially outweighed by the danger of the unfair prejudice and confusion of the issues. What is clear from the defendant's filing is that the defendant doesn't like the piece of the state's evidence, the bushy eyebrows, and therefore would like to keep this piece of evidence from the jury. However, his arguments are without merit. As shown above, Dylan gave consistent descriptions of the male she saw at the time in question. One of those consistent descriptions is that the male had bushy eyebrows. This description is clear. It is not confusing and therefore will not confuse a jury. The fact that this description may or may not implicate defendant is not a reason to keep this fact from the jury's consideration. It is not reasonable to believe that the jury will convict the defendant based on the status of his kept or unkept eyebrows. While the fact is prejudicial, it is not unfair. Do you guys think the eyebrows should play a role in this? Come on, tell me what you think. Not the purple dragon. If you missed the Stephen Stearns live, please go back and rewatch. Give your girl a like. Doesn't his eyebrows look trimmed out? Yeah, we were talking about that earlier. Hollywood unibrows are in, I heard. Yes, but minimal. Okay. Yeah, I don't think you should be allowed to maintain them all. We need to see them bushy things, right? It's a feature that was identified. I don't know. I mean, what if you were at a party and it was dark and you were drinking and something happened and someone was like, oh, it was smelling like she has like bushy eyebrows. You know what I mean? Like, I don't know. Is that fair? Quote unquote. The defendant's reliance 602 is illogical. Under 602, a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness had personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness' testimony. Dylan will testify based on her recollection of what she observed on November 13th, which will include her observations of the male in the 1122 King Road residence at the time of the homicides having bushy eyebrows. Dylan is competent to testify. The defendant next takes another run at challenging Dylan's competency to testify. Every person is competent to testify except persons whom the court finds are incapable of receiving just impressions of the facts, which they are examined of relating them accurately. The defendant has already tried and failed at challenging Dylan's competency in previous filings. This court has held defendant's own proffer establishes that Dylan's accounts were remarkably consistent through her multiple interviews with law enforcement. Order on the defendant's motion for Frank's hearing, filed February 19th, 2025. Also, Dylan, quote unquote, was a direct witness and was able to consistently articulate the details she remembered throughout each interview, especially as the facts relied on such search warrant affidavits. Despite the fact that she claimed her memory was fuzzy or that she felt like it was a dream or that she was still intoxicated. Applying the court's reasoning in Houston, in this case, the defense will be able to probe into Dylan's capacity and opportunity for observation, her attention, interest, and distraction at trial. The jury is perfectly capable of assessing Dylan's credibility by weighing her testimony, its consistency, or alternatively, any deficiencies elicited through cross-examination. Conclusion. In conclusion, the state respectfully requests that this court rule consistently with its previous findings that Dylan is credible and competent to testify and allow Dylan to testify at trial regarding her recollection of the male she saw in her residence during the early morning hours of November 13 as having bushy eyebrows, because this evidence is relevant and admissible. This was filed the 17th of March. They basically played the I'm young and drunk, but at the same time, professionals are saying that this is a freeze instead of a fight or flight. So I don't know. Right. If she was intoxicated, are any of her statements credible? Very, very good question. I think I mentioned this earlier. He must have looked like a caterpillar before he started tipsy. I mean, if it's something she's truly seen, then yes. I have the rest of the documents from this week, but we're going to continue those tomorrow and this weekend. I'm going to play one more clip with the new updates. This clip is from today, and then we'll end this live here. We'll continue this weekend. We're going to continue deep diving these documents. You know me, I love to document. So we're going to go through them and I'll review them beforehand. And then we have a new case tomorrow that I want to talk about. And then we have Melly After Dark. So please make sure you are subscribed, join the fam, do all of the things. We're fun. We're a lot of fun here. Too much fun. Too much fun if you ask me.
A selfie pulled from a phone, a K-bar knife bought on Amazon, and a sketch of a mask. Those are just some of the big revelations in the case against Bryan Kohberger.
So this is from today. This clip just dropped, so I want to play it.
I have the biggest bombshells dropped by the state and the defense. Plus, will prosecutors actually call Bryan Kohberger's family to testify against him?
Thank you, Pantera, for gifting.
Welcome to Crime Fix. I'm 𝗟𝗏𝗃. We've learned more about the evidence in the Idaho murders case in the last week than, frankly, we have in the last 2 years. The new information comes from court documents filed by prosecutors and Bryan Kohberger's defense attorneys in preparation for his trial this August. And let me tell you, the defense is not one bit happy about that selfie of Bryan Kohberger that prosecutors want to use at trial. It was taken 6 hours after the murders. We'll have more on that in a bit, along with a description of him having bushy eyebrows. Both sides have revealed details about the alleged murder weapon and that selfie. There are also details about DNA that police say was found on a Ka-Bar knife sheath found at the crime scene. I'll get to that later. Kohberger maintains he didn't murder Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle in the early morning hours of November 13th, 2022. But prosecutors say they have evidence that proves Kohberger committed these murders, and they may call Kohberger's own family members to testify against him. In a document discussing family members of victims being allowed in the courtroom during the trial, prosecutors wrote, "The state may call members of the Kohberger family to testify at trial. Prior to start of trial, the state anticipates it will motion the court, or the court will, on its own accord, generally exclude testifying witnesses from the courtroom so that they cannot hear other witnesses' testimony." Prosecutors are objecting to members
We are going to read this document too.
Of Kohberger's family who are on the state's witness list from being in the courtroom during the trial until after they testify. So which family members could be called to the stand by prosecutors? We know Bryan Kohberger's father, Michael Kohberger, drove from Pullman, Washington to Pennsylvania with his son in December of 2022. That cross-country trip was pre-planned for the holidays. Could Michael Kohberger be called to testify about that drive or something that happened once they arrived at the Kohberger home in Pennsylvania? Maybe. Dateline had reported in 2023 that one of Kohberger's older sisters was suspicious of her brother's behavior over that holiday and suggested he may have committed the murders. One of those sisters is Amanda Kohberger. She's seen in these photos from a movie she was a part of filming back in 2011. Ironically, it involved a stabbing. But what else could the Kohbergers testify about? Well, we know from the defense that the Kohbergers shared an Amazon account, and prosecutors say Bryan Kohberger bought a Ka-Bar knife on Amazon. Kohberger's lawyers have asked the judge to bar prosecutors from presenting evidence of the Amazon account's click history, arguing it was a shared family account and AI can influence what a customer clicks on. I want to tell you about a free app that I've tried. It's called 𝗍𝗃. It gives you cash back on things.
Let's move forward from the
kit.
Oh, wait, I went too far.
And now we may have a hint of what the defense may claim about that Ka-Bar knife. And a new document they write, the state ignores that the Amazon records reflect a household of users on the Amazon account at issue and a long list of items purchased over a period of several months for a road trip or hiking to include a roadside repair kit, a tire inflator, a backpack, and bear spray. Is the defense going to say that Bryan Kohberger bought this knife for a road trip or to use hiking? Not sure, but prosecutors say the click history is reliable. Prosecutor Ashley Jennings wrote, Kohberger's click activity, which shows a purchase of a Ka-Bar knife and sheath before the homicides, makes it more probable than it would be without the evidence that the Ka-Bar sheath found at the crime scene was Bryan Kohberger's. Second, Kohberger's click activity after the homicides makes it more probable than it would be without the evidence that Kohberger had a reason to search for a Ka-Bar knife and sheath after the homicides. These facts are of consequence to determining whether Bryan Kohberger committed the homicides at 1122 King Road, the central question before the jury. This evidence is clearly relevant. So prosecutors dropped that bomb toward the end of their response to that defense motion, confirming after all of this time that Bryan Kohberger bought a Ka-Bar knife, sheath, and sharpener on Amazon. Jennings went on to write, the defendant touches on the issue of identifying the account user making the Amazon search inquiries as shown by click activity. The state recognizes that the identity of the user making the inquiries is relevant, and the state intends to rely not only on the click activity, but also other circumstances to connect the defendant to the original knife purchase and subsequent search inquiries for a replacement knife and or sheath. This will include the defendant's financial activities, the click activities vis-a-vis other events, such as the homicides, a related purchase activity connected only to the defendant, and testimony from witnesses with knowledge that the defendant purchased a Ka-Bar knife.
So careful what you buy on Amazon. We might hear all about it. Just kidding. Thank you, Pantera. Yes, yes. Trust me, I've been dreaming about the buzz balls.
So could one of the Kohberger family members be testifying about the purchase of the knife? They would have access to that shared family account. We'll have to wait and see. Next up, the state has asked Judge Hippler to bar the defense from using the "some other dude did it" defense. Prosecutors say the evidence points squarely at Kohberger, but the defense says they should be allowed to point the finger at other suspects in an effort to present a full defense.
Thank you,
Ann
Pantera.
Taylor wrote,
I'm
the
gonna
state
buy
argues
balls
that
for
literally
the-
thousands of tips regarding possible perpetrators were received by law enforcement during the course of the investigation, and that none of these tips were substantiated, with exception of information regarding the defendant. The state is correct that over 45,000 tips have been disclosed and tips continue to come in daily. This case is full of alternative perpetrators. The state has chosen to focus on Mr. Kohberger at its own peril. Mr. Kohberger will produce offers of proof related to many alternate perpetrators in this case that will meet Idaho rules of evidence 401, 402, and 403. Many alternate perpetrators can be connected to the crime. The defense has a footnote in that paragraph that references a sealed motion to suppress the genetic genealogy information in the case. So is the defense referring to alternative perpetrators mentioned in the genetic genealogy searches performed by the FBI? It sounds like it. Now, there's been a lot of fighting in court over that investigative genetic genealogy evidence the FBI used to identify Bryan Kohberger as a suspect. Police said that DNA taken from this part of the snap on the K-bar knife sheath found next to Madison Mogen came from a male, and it was a single source, but they had to use that genetic genealogy to trace it to Bryan Kohberger. The jury isn't going to hear about this at trial. When it comes to genetic genealogy, they'll only be told that police got a tip that led them to Kohberger. The defense claims the prosecution is going to sanitize this. Prosecutors fired back, writing, "It is unclear what the defendant means in the last sentence of his reply, since this testimony will be sanitized for presentation to the jury to avoid the IgG process. It must also not falsely suggest that there was any other evidence or tip that led the state to Mr. Kohberger. There is substantial evidence gathered both prior to the tip and subsequently, leading to Mr. Kohberger being the person responsible for the November 13th, 2022 homicides and burglary. The state will certainly not falsely produce or refer to this other evidence, but will rely on all of this evidence at trial to establish the defendant's guilt." Now, it will be interesting to find out what evidence police gathered prior to the tip that led to Kohberger, because Moscow Police Detective Brett Payne testified until December 19th, 2022, he had never heard the name Bryan Kohberger until the FBI gave him that name. Now back to the sheath and the DNA from Kohberger that prosecutors say was found on the snap. The defense doesn't want the manager of the DNA lab in Idaho, Rylene Nolan, calling the DNA touch or contact DNA or offering an opinion about when or how Kohberger's DNA ended up on the sheath. Kohberger's lawyers say DNA can be transferred onto an item any number of ways, but prosecutors say not so fast, and so does Rylene Nolan. Nolan wrote in an affidavit, "The phrase touch DNA is widely used in the forensic DNA community and was used in Dr. Ruth Ballard's expert witness disclosures for this case when referring to the DNA on the knife sheath. It is typically used to describe DNA collected from items of evidence in areas on the item that would most likely be touched by the user of that item." Prosecutors write, Ms. Nolan's use of the phrase touch DNA is not unique, but common within the field. Most tellingly, defendant's own DNA expert plans to use the phrase touch DNA in reference to the DNA on the knife sheath. No blood, hair, or DNA from him was found on any of the crime scene evidence except the touch DNA on the knife sheath. Experts in other cases also use the phrase touch DNA in the same way.
Yeah, I'm like still shook about that too, and I'm sure you guys are. How is that the only piece of evidence he left behind? I know we've probably mentioned
And
it
Rylene
before.
Nolan is ready to testify about the amount of DNA on the sheath. The term trace DNA implies amount. The word trace is defined as a very small amount and is used in the scientific literature when describing evidence samples with low amounts of DNA that do not yield a profile or only a partial profile, I would not be willing to use that term, and it would be inappropriate to apply that term to the DNA on the knife sheath because a trace amount of DNA is not what was detected on item 1.1, and referring to it as trace DNA would be misleading to the trier of fact. So Nolan says this was not a small amount of DNA. Recently, I spoke to DNA expert Kristen Slaper about that amount of DNA taken from the sheath.
So 0.168 ng per UL. Tell me, how much DNA is that? Is that a lot of DNA? Is that a little bit of DNA?
Yeah, so in my opinion, that's a lot of DNA. That's 0.168 nanograms per microliter. And at least in my lab, we would target.
Yes, SW. I know nothing in the car. I think that is pretty wild.
One nanogram of DNA. So you would need 1 microliter, which is a very tiny amount. If you took all of that sample and you put it into the system, it would be way too much for the system to handle to produce a DNA profile.
You make a good point. If Bryan is guilty, then I want to know who else are his victims, because nobody just jumps to 4 bodies. Right. We hear in true crime all the time, right? That, like, how does one commit a crime this horrific for the first time? There must have been signs of violence prior to, right?
The amount of DNA, the target that you have for your system is all based on lab validation. So this lab would have had a validation that said this is the ideal amount to get a single source profile or whatever. But you can get a DNA profile with far less DNA than what is there. So I think it's a decent amount of DNA. Can you say where it came from? No. I think the other thing that's important is it's single source. So when you start to talk about transfer, and I think even in one of the documents, they have a diagram of the different types of transfer, whether it's primary transfer, secondary. When you're talking about a single source profile that has been transferred onto an item, it seems like it stands to reason that it is from the direct application of that DNA onto that item. Now, if you're talking about touch DNA, people shed DNA in various rates. And that's one of the biggest arguments that you'll find, is that there's no way of knowing if I touch something one time and then you swab it, will you get my profile off of it? Versus if you swab the same item, you may shed more DNA or more skin cells onto an item than I do. So there's no way of knowing, but ultimately it's from one person, which means if someone else transferred Bryan Kohberger's DNA onto this item, they had to have something from Bryan Kohberger and put it on the item without also mixing themselves into there. So the biggest case that, probably in the history where planting evidence was known is the O.J. Simpson trial or the O.J. Simpson case. And if you recall the evidence in that case, there was a lot of it. But they had a vial of O.J. Simpson's blood that they had collected from him. So the idea that they could take his blood and potentially put it on items to plant the evidence, blood has a lot of DNA in it, and they could then take it. They would have had to know who Bryan Kohberger was. They would have had to have a sample from him and also put only his DNA onto this item.
Now, remember that.
Yeah, that is pretty wild. I'm not going to lie. She makes really, really good points. Against all logic, as a criminologist, BK knows how to address and prevent from leaving DNA. Also, he had more than 1 month to get rid of evidence from the car. That is very true. You make a very good point. And Holly said Maddie was the only one they were saying was his target, though.
Selfie of Bryan Kohberger that I showed you last week. Prosecutors say they pulled this off of Kohberger's phone and that he took it 6 hours after the murders. They want to show it at trial to back up the testimony of the surviving roommate, DM, who described the man she saw walking through the house as having bushy eyebrows. Well, Kohberger's attorneys, they're not happy about that selfie. Alicia Massif writes, the photo of Mr. Kohberger that the state attached to its response is not relevant and is overly prejudicial. This is akin to the state trying to identify Mr. Kohberger for DM or create its own corroboration for her. DM previously said that she could not identify him. There are literally millions of people in the world who might be described as having bushy eyebrows. The term itself is subjective, and DM has a fascination with drawing eyes and eyebrows. Massive goes on to write that a detective was the first to ask DM about the color of the man's eyebrows on the day of the murders. And then DM didn't bring up the bushy eyebrows until November 17th in another interview with police. And look at this. Massive included this sketch from DM. Detectives asked her to draw the type of mask that she saw that man wearing. I flipped it around so you could see it from top to bottom. Prosecutors are now revealing that Kohberger bought a black balaclava from Dick's Sporting Goods in January 2022, and that it's similar to the mask that DM sketched. Now, Kohberger's lawyers are pushing back against the bushy eyebrows description. They say allowing it would basically be pointing the finger right at Kohberger. Meanwhile, prosecutors have included a photo of Kohberger's driver's license from Washington State. The photo was taken 4 months before the murders. Kohberger's lawyers are also responding to prosecutors saying their motion to strike the death penalty should be denied because Kohberger has autism spectrum disorder. The defense writes, Mr. Kohberger's ASD makes a fair and just trial a challenge. The state argues news coverage is not informative on this topic. The state benefits from the biased news media. Public sentiment is that Mr. Kohberger's physical presentation makes him look guilty through no fault of his own. His flat affect, intense gaze, awkward body posture, holding still in the courtroom, inability to react and process what is happening in the courtroom, and inability to show emotion could cause enough juror bias to...
I need to see the medical records if he really is autistic. It just suddenly came out during this trial. I'm sure there's medical records. I haven't seen them.
Without a doubt, his ability to testify in trial and the decision to testify will be nearly impossible for Mr. Kohberger. He has no ability to perceive what it will feel like and whether he should in fact testify. His inability to read the room, understand the threat that cross-examination will present, or explain himself in socially acceptable ways without prosody of speech presents insurmountable hurdles for him. The defense also points to Kohberger's arrest in Pennsylvania to show how his autism impacts him. The defense writes he has an inability to assist with mitigation evidence and understand the magnitude of his case. By way of example, when he was arrested in his home with a full SWAT team, doors broken and parents zip-tied, he made small talk with the detective in the back of the car during the ride to the police station. He asked the officer about his education and suggested that they get coffee at a later date. He did not perceive the profoundly serious nature of the moment and exhibited no perception of what was happening. All right, so there is all...
I can't wait to read that document. If you research the kids involved and how the families are involved in the community, all the pieces will fall together. I'll look into that. Yes, I am Holly. I'm on there. Hit me up. I'm sure all his searches on the web will come out. Yeah. I want to know what the Discord or Instagram report, like, do we know what was going on there? That would be very interesting. Honestly, the eyebrows things isn't enough. There's no crime in having thick or bushy eyebrows. Right. I agree, Pantera. Yes. Parents zip tied. I know. We're going to watch a little bit more of this.
A lot to talk about here. We haven't even gotten to all of it yet, but we are going to do that with Josh Ritter. He is a former prosecutor, currently a defense attorney in Los Angeles. So Josh, I have to get your thoughts on possibly hearing from members of Bryan Kohberger's family. The state says they may very well call members of his family to testify against him. Your thoughts on that? Because we heard a lot about him possibly acting very strangely when he was home for the holidays. And obviously we know his dad drove cross country with him from Washington to PA.
Yeah, it's wild stuff. I mean, you just usually do not see this. Though it's not, there's nothing wrong with it. It's just kind of usually the defendant's family is off bounds for the prosecution. But in this case, it kind of makes sense if you think about it. For one, the reasons you point out, it's probably important for jurors to understand what he was doing when he was back at home in Pennsylvania. Does that include things like cleaning up his vehicle? Does that include things like discarding items in the home? Does that include things like being very meticulous as to what was being put into the garbage? This is all circumstantial evidence of somebody who might be covering up a crime. They also might be calling them to just kind of create a timeline. Where was he? When did you last speak with him? Where can we put him? Is he still someone that we can put at the murder scene? What was the discussion as to why he was then going to travel back home within weeks of the murders? But the other thing, too, is the new revelation that we've had about the Amazon account. And it may be that this was a shared family account. And so they may need someone to lay the foundation as to who had access to that account, who was making purchases on that account, and what purchases, and we know one in particular that is very interesting, who made those purchases and when.
Yeah, and
so wait, they think that it was someone in the family, in the household? Is that what they're hinting at?
He said they have a witness or witnesses that have knowledge of Bryan Kohberger having a Ka-Bar knife. And so that's making me think, I mean, that could be any number of people, but that makes me think, is that a family member who either logged into the account after they thought he was acting weird in Pennsylvania and they're like trying to put the pieces together, or did they see him with this thing and they're like, why do you have this thing? You're like a PhD student. You're not a knife guy.
Exactly. And that's exactly what I was thinking as well, is it could be one and the same. The family members are also the people who are going to testify as to him purchasing and actually being in possession of that knife. It could be that the knife was delivered to one of the family members' homes with his name on it. I mean, there's any number of things that could establish him being the one in possession of that knife. It could also include classmates, friends, acquaintances who may have ever seen him in possession of a knife like that. I will say this, that is a remarkable type of knife. And what I mean is that's not a knife you commonly see in someone's home. I feel like it would be the type of knife that you would remember someone being in possession of.
I mean, anyone can have a knife, really. I don't think you have to be a particular style to have a knife or personality or even a doctor, but it was a very particular knife.
A kitchen knife or some sort of typical kind of pocket knife that some people carry. That's a knife that I feel like people are going to remember seeing in someone's possession.
Yeah, to your point, Josh, look at this thing. I mean, this sheath is as big as my head. I mean, somebody remarked to me the other day about this, like when I got this thing. I mean, look at it. It's huge. And it says Ka-Bar USMC. I don't have the knife in here, but like the knife, I mean, think about it. This is a big knife.
No, it is. And you look at it and you immediately wonder, what in the world does somebody need a knife like that for? Like I said, it doesn't appear to be kind of a common pocket utility knife that somebody might carry around. I used to carry around one of those Swiss Army knives. This is a large knife that is not going to easily fit into a pocket. That sheath itself is meant to be tied to a belt. I mean, it's just the kind of knife that, like I said, is going to draw attention and likely have people remembering when they last saw it.
Now, there are other purchases that the prosecution, they've got records, all these records they just want to introduce. I mean, they're talking about purchases that Bryan Kohberger made at Dick's in June of 2022 and also Under Armour. And I'm thinking to myself, they say that he was in the house. There's this guy in all black wearing a mask, wearing black boots, all black. You're not going to introduce these purchases unless you think that they were involved in the crime. You have to think that they think he bought something at Dick's and Under Armour that he wore to the crime scene.
I think you're.
Holly said something earlier about he was following one of the girls on Instagram for like years prior. I'm going to look into that. And good to see you, Kelly. Thanks.
You're absolutely right. We're obviously doing a little bit of a guessing game here, but I think you're absolutely right that it's, I was immediately thinking something like gloves, clothing, like you said, boots could be part of it. It could also be tools. If there's something that is a tool that might be a pry bar or something that could be used to gain access to somebody's home, anything that would look like, what we would consider like a residential burglary kit might be items that they are most interested in, especially if these are purchased close in time before the murders took place. You're purchasing gloves 2 years ago, maybe not as important and not as perhaps not even admissible in court, but you're purchasing items that look like they might be involved in a break-in and murder within close period before the murders. That's going to be something that the prosecution's going to want admitted.
And
I'll have
were
to look
was
into
the
that, Holly.
prosecution able to find those items after the homicides? That's another question. There were also purchases.
Wait, Holly says it came out at the very beginning. I'm going to look into that. And S Dub says, why can't I see that comment? I want to know if this was before or after he was accepted into. Oh, okay. Good point. I heard he was following both of the girls, but he liked a lot of Maddie's posts. Oh, so he was like infatuated and obsessed with Maddie.
At Walmart, and surveillance video from Walmart that the prosecution wants to introduce. Let's go back to the sheath just for a second. The defense has said nothing about, yeah, he bought a K-bar knife and sheath. Like, I mean, what are they going to say? Because if the state wasn't able to recover that item in his apartment or at the house in Pennsylvania, they have to explain that. How are they going to explain that Bryan Kohberger bought this in March of 2022, that his DNA is on here? They recover his DNA from here. Maybe they're going to say, yeah, it was planted or whatever, or it got on there from another type of transfer. Where did his sheath go? Did he sell it to some guy in a parking lot? Did somebody steal it?
Right. Yeah, I mean, what you're outlining is just how difficult a case it is for the defense. You know, this whole case, in my view, comes down to that DNA found on the knife sheath. Everything else is circumstantial, and everything else the defense might be able to present some sort of argument for. How do you explain how your client's DNA ends up on a knife sheath recovered from the crime scene where a stabbing took place? And they're going to challenge it two ways. They're going to either challenge it legally and try to attack it foundationally and say why it shouldn't be admitted as evidence. Well, they've done all of that and they've failed. Or they have to present some sort of reasonable and innocent explanation as to how their client's DNA ended up on that knife sheath. Well, we started to hear things like, well, it was planted, and getting maybe perhaps a glimpse as to what those arguments would be. But then when we realize that the prosecution has evidence of him purchasing that knife, I think those arguments even go out the window. Now we know he's been in possession, or there's good circumstantial evidence that he's been in possession of a knife, likely the murder weapon. And to your point, where is that murder weapon now? If the defense doesn't come up with some sort of receipt that he sold it, some sort of eBay history showing that he sold that knife, a friend who says he gave it to me as a gift, then everyone is going to assume that that knife is either still in his possession or was discarded by him after these murders took place.
While he was stargazing, eh? He disposed of it while he was stargazing. And they did ever disclose there was an essay. I don't think they did. Exactly. The DNA is hard to refute. And hello, Vivian. Welcome. Did I miss it? The gifting? I'm sorry. I don't have my StreamYard doesn't show me that. But thank you. Oh, yes, you sent a gift. Thank you, Michael. I appreciate that. Okay, we're going to play I know, we already heard it, but we're going to play it one more time, the call, before we end the live. It might be
leading
clearer
to the
here.
discovery of the 4 victims.
911 location of your emergency.
Hi, something is happening. Something happened in our house. We don't know what.
What is the address of the emergency?
Hi, Antonio. Thank you for being here.
What is the rest of the address?
Oh, Kings Road.
Okay. And is that a house or an apartment?
It's a house.
Can you repeat the address to make sure that I have it right?
I'll talk to you guys. We live at the White, so we're next to them.
I need someone to repeat the address for verification.
The address, King Road.
Okay, and tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. Yeah. Hi,
and are you with the patient? Okay, I need someone to keep the phone, stop passing it around.
Can I just tell you what happened pretty much?
What is going on currently? Is someone passed out right now?
This is so much more clear
I
than the first
really
call.
know, but pretty much at 4 a.m.
Okay, I need to know what's going on right now if someone is passed out. Can you find that out?
Yeah, I'll come. Come on, we gotta go check.
She does cut her off.
But we have to.
Wow.
Is she passed out? What's wrong? She's not waking up.
Okay, one moment. I'm getting help started that way.
Okay, thank you.
Thank you, Michael.
Okay, and how old is she?
She's 20.
20, you said?
Yes, 20. Here's one.
Okay.
Hello? Hello?
Okay, I need someone to stop passing the phone around because I've talked to 4 different people.
Okay, sorry.
I don't like that
the
attitude.
phone.
Is she breathing?
Hello?
Is she breathing?
No.
Okay.
All right.
Mm-hmm.
Dylan, I need you to keep talking to them, okay? I can't talk to them. I need you to talk to them.
Hello.
Okay. I've already sent the ambulance and law enforcement. Stay on the line. If there is a defibrillator available, send someone to get it now and tell me when you have it.
Say that again. There's a police here right now.
Okay. If there is a defibrillator available, send someone to get it now and tell me when you have it.
We don't have one. I think yes. Do you have a defibrillator? Yes, we have one.
Are you talking to the officer?
Yes.
Okay, I'm going to let you go since he's there with you and can help you.
Okay, thank you. Bye.
Okay.
That is wild. That was way better than the first call we played. The sound, at least. Well, we got through quite a few documents and quite a few clips. So I appreciate you guys for being here. We will continue Bryan Kohberger this weekend. I have a new case to talk about tomorrow evening. So I hope you guys can make it and tune into 𝗟E:E After Dark. It's the late night version, true crime hangout. So make sure you guys subscribe, become members, hit the like button. Shout out to all my mods. Love my mods. They're the best. Thank you everyone who gifted and was here to watch and listen to the documents. Thanks SW for being here. I will see you guys later, and the rest of the week I'll be live. So we'll be tuning into a lot of true crime. Thanks for being here. Make sure you hit that like button on your way out. See you later.
Try to hide away, so all they do is work. But nobody can hide once she gets a hold of that paperwork. So don't you dare come in here acting like a jerk. Bands might make her dance, but new court docs will make her wanna twerk. Dark hair shining in the Cali sun. Really on the case, so no point in trying to run. You Sims can ask for feet pics, but you getting none. It's 𝗟𝗃 with 𝗟E:E, let's have some fucking fun. So if you're feeling for true crime, like it's a drug, 𝗟𝗃 with 𝗟E:E is your motherfucking plug. Going so hard on criminals, they'll call their mama for a hug. She's finding out all the stuff they try to sweep under the rug. Dark hair shining in the Cali sun, 𝗟E:E